A big win this morning, Kate, for black voters in the state of Alabama. The Supreme Court ruling in a 5-4 ruling just moments ago that the state of Alabama must redraw its congressional maps. Now, this was a case where black voters had challenged the congressional maps that were actually in place for the last election in 2022, saying that they only had a majority in 1 out of 7 congressional districts, despite the fact that black voters make up 27% of the state's population. What's interesting here is that this Supreme Court, a divided Supreme Court with Justice Roberts and Chief Justice Roberts and Justice Kavanaugh siding with the liberals and then 4 of the conservatives dissenting, they actually ended up siding with the district court. And more than a year ago, the district court had said that these congressional maps should be redrawn. It was then appealed up to the Supreme Court. The Supreme Court, though, said, no, we're not going to make them be redrawn for the 2022 congressional elections. So essentially, a bad map was in place in 2022 where voters maybe were disenfranchised for not having enough representation. The Supreme Court now saying those maps were essentially wrong. State of Alabama, you have to go back and redraw these congressional maps. I mean, this is a very big win for people who may in the future want to challenge voting maps. That's because over the past several years, the Supreme Court has really gutted many sections of the Voting Rights Act, really depleting the ability of several groups, many groups, to challenge different aspects of elections. But in a surprise move from this case, this court this morning, they're actually maintaining that power of minorities to challenge voting maps, other election rules under Section 2 of the Voting Rights Act. Kate, this is definitely a surprising decision. There were a lot of court watchers sort of holding their breath, thinking that the court would eviscerate Section 2 of the Voting Rights Act. But the court here doing just the opposite in a 5-4 decision, handing a big win to black voters and telling the state of Alabama, you need to redraw your maps to give greater representation for the 27% of black voters in your state. Kate.
This is, I mean, you hit it perfectly, Jess. This is super interesting and goes counter to what a lot of court watchers were seeing as the trend, as a trend they would see of the direction of the conservative court going, and what this means now with the conservative majority of 5-4. Who wrote for the majority? Do you have that?
Well, that's what I was actually just about to mention, because, you know, Chief Justice John Roberts is the one who wrote this 5-4 opinion, really upholding Section 2. He has been the one on the court that has been the most critical of the Voting Rights Act and has actually helped dismantle parts of the Voting Rights Act. So in this case, he's saying that the district court, they went through their fact finding, and what they found is that they should have redrawn these maps. And the court today, the Supreme Court, agreeing with that, not dismantling any of Section 2 and saying to Alabama, go back and redraw these maps, because essentially they're just not fair. They violate Section 2, which prohibits any election rule that would result in the denial of the right to vote for a minority group. Kate.
Jess, thank you so much. I think that we still may have some more decisions coming down still this hour, so we'll get back to you as those come down. In the meantime, Jess, we'll get back to listening to the court as they're handing down these decisions. Let me bring in Ellie Honig for a little bit on this. Section 2 of the Voting Rights Act, Jess laid it up really wonderfully and making it clear on kind of how surprising this is to a lot of people and what the justices have decided here, really upholding the power of Section 2. What do you think of this, Ellie?
Well, absolutely a surprising decision, Kate, and a monumental decision, really, that sort of saves the day for voting rights advocates. The Voting Rights Act historically has had 2 pieces of it that gave it any teeth. First, there was, in the past, something called Section 5 that required that certain areas of the country get pre-clearance from the courts, from DOJ, before enacting a new map. But that was struck down in 2013. It was essentially gutted in 2013. And that left voting rights advocates with only what we call Section 2 of the Voting Rights Act, which prohibits discrimination based on race. And the question was, and I think the expectation was, will the Supreme Court, with its 6-3 majority, use this occasion to get rid of Section 2 as well, which would have essentially left the Voting Rights Act as mostly an empty shell. Instead, what the court has done is reaffirm Section 2, saying, yes, this is still part of the law. And the thing that I think is really notable here is the coalition that pulled together to do it. You had the 3 liberal justices, as expected, joined by Chief Justice Roberts and Justice Kavanaugh. And so that sort of bipartisan, cross-ideological grouping has bound together and kept the Voting Rights Act a vital part of our books.
Can I ask you really quick, Ellie, does this suggest to you, kind of when you see this coalition, just that how bad that map was as it was drawn in Alabama?
That could be part of it. As Jessica said, there's 7 congressional districts in Alabama, 27% African-American population, but this map would have given African-Americans a substantial say, potentially a majority, only in one of those districts. If we choose to take the sort of optimistic view here, this may be an increasingly rare instance where the justices actually look to apply the law and they're not outcome based. Because what we see so often is, the 6 conservatives are going to come down with the conservative outcome. The 3 liberals are going to come down with the liberal outcome. Instead, it looks like what they've done here is give a strict reading to the law itself, strip out the politics around it, and came to this decision.
And I think a lot of people will be looking at this as perhaps a shape of future decisions, maybe on a range of subjects, with the Chief Justice and Justice Kavanaugh serving as this moderate swing vote that could push decisions one way or another. Obviously, this has a very immediate practical implication on maps, congressional districts, and not just in the state of Alabama. Let's get Diane Gallagher on the phone with us right now. Diane, I know you've been looking at this as well, and there are other states very much at play here.
There are, but I do think that we should consider what Ellie said, John, that this may not be an indicator for other cases. This ruling came as a surprise to even many voting rights advocates and those who focused on redistricting, especially the way that we have seen this break down here. There, of course, are them watching additional cases, specifically those that deal with redistricting cases when it comes to violating the Voting Rights Act, as well as intentional gerrymandering on racial or on political partisan lines. We're looking at cases out of Utah, in North Carolina as well, a case that we've been waiting to hear from the U.S. Supreme Court, the Moore versus Harper, which became a bit more complicated. It deals with that independent state legislature theory once the state Supreme Court of North Carolina knocked down a previous ruling after the political makeup of that state court changed. We're waiting to see if, in fact, the U.S. Supreme Court will just kick that back, saying they don't need to rule on that particular case due to those changes at the state court level. But it's unusual to see this for these voting rights advocates who have said that it came as, again, a surprise to them, for them to acknowledge that this, in fact, was a violation of the Voting Rights Act, especially because of Roberts and his past majority opinions on gutting the Voting Rights Act. Of course, back in 2013, I'm seeing now text messages and emails coming in from those that I've worked with on these cases, these particular things for years now, saying that they're shocked even about this, failing to draw that second majority black congressional district in Alabama, where black voters make up 27% of the population in that state, only hold 1 of 7 seats, determining that this was intentionally breaking those up, which was the argument that lawyers had been making, and something that we've seen in voting rights cases continuing through the basically diluting the strength of black voters. We've seen this in cases in Florida as well, dealing with on more of a state level or legislative level. But look, this is a major and unexpected win for voting rights advocates. It also puts into perspective that order back in, again, 2022 that actually allowed them to use a map for the 2022 midterm. So this map was used in the 2022 midterm. Justice Kavanaugh, of course, changing sides from that initial, to make this a 5-4 ruling. But this is a very big deal, and it could perhaps be seen as encouraging for voting rights advocates. But again, I think there's some caution still and some trepidation about what this may mean in future for additional cases. Perhaps this one was just so egregious. But again, they do look back just a year ago at that unsigned ruling that allowed these maps to go into effect for that midterm and what the implication may have been for even the current makeup of Congress.